Hello, my name is Anthony Kroese, a Goldberg-Segala Associate and member of the New York State Bar Association. Although Facebook has benefits for all, law students, lawyers, and judges should be especially careful when regulating their Facebook usage. With respect to lawyers, the Supreme Court of the United States has held that lawyers have an obligation to refrain from making statements that damage the integrity of the judiciary. Despite Facebook's safeguards, as well as the protections provided under the First Amendment, attorneys remain bound to the model rules of professional conduct, the American Bar Association's framework for the ethical practice of law. Let's consider several applications of model rules to an attorney's usage of Facebook. For example, Model Rule 7.1 states that a lawyer shall not make a false or misleading communication about the lawyer or the lawyer's services. When a lawyer posts information on Facebook about the legal services that he or she offers, it has the potential to be seen by future clients. Once in the hands of future clients, these posts may constitute lawyer-client communications. If a lawyer is not careful, he or she may be found in violation of Model Rule 7.1. For example, if a lawyer updates his or her status on Facebook stating that he or she just won a huge case for his or her client, such misleading information could influence potential clients into hiring that lawyer, and the lawyer would then be in violation of Model Rule 7.1. It is also important to keep information about ongoing cases private. Model Rule 3.6a states that a lawyer shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. In short, Model Rule 3.6a cautions lawyers from posting information on Facebook about ongoing cases that may be construed to be influential on court proceedings. The purpose of this model rule is to protect the integrity and fairness of the judicial system, as well as protect attorneys from detrimental situations. For example, if an attorney were to post derogatory comments on Facebook about a certain racial background, the defendant could move for a new trial on the grounds of prosecutorial misconduct, citing the attorney's actions on Facebook. More seriously, attorneys should warn their clients about what they post on Facebook, as it may result in waiving the attorney-client privilege. Another example is Model Rule 5.5. Model Rule 5.5 states that a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction or assist another in doing so. Facebook allows people to share information without any limitation or border, which may be problematic for an attorney that unknowingly violates ethical rules by advising someone who does not live within their licensed jurisdiction. If an attorney chooses to provide legal commentary on Facebook, it is important to understand the difference between providing legal information and legal advice. While legal information provides a general discussion of legal principles, trends, and considerations, legal advice typically provides more specific recommendations based on the unique facts of an individual's case. Additionally, attorneys should be careful not to inadvertently form an attorney-client relationship through Facebook use. Model Rule 1.18 states that a person who discusses with a lawyer the possibility of forming an attorney-client relationship with respect to a matter is a prospective client. As a general consideration, it is crucial that practicing attorneys conduct themselves in a way that is worthy of the legal profession. Although Facebook offers many benefits to the public, it can also be very damaging for attorneys without even realizing the consequences of their actions. Attorneys, like others working in professional settings, are being disciplined by the American Bar Association, the State Bar, and by employers for information shared on Facebook. Although privacy settings enable an attorney to keep certain information confidential, it is important to remember that it is almost impossible to remove information posted online, and someone else that does have access to the attorney's Facebook profile may share such information with the public. It is also important to note that any information accessible without offending the attorney is essentially open to the public, and thus may be detrimental to an attorney in the eyes of an employer, as well as lead to sanctions from the State Bar. Regardless of the amount of care taken to keep information private on Facebook, misleading and inappropriate posts and pictures are not worth the risk of getting sanctioned. Therefore, attorneys should avoid posting any inappropriate content that could be viewed by the general public and run afoul of the model rules. By choosing to work within the legal system, attorneys are held to a higher standard and must sometimes surrender their social media freedoms. As technology, as well as social media, continues to evolve, attorneys will need to remain vigilant in upholding the model rules. Technological abuses, whether intentional or accidental, will only damage the legitimacy of the legal profession and lead to less faith in the ability to self-regulate. The legal profession and general public deserve the greatest level of integrity, and as such, All attorneys must carefully monitor information shared online, especially on Facebook, the world's largest social network.